Federalist No. 22, 1788, by Alexander Hamilton, December 14, 1787, published during ratification debates of 1788. The same subject continued, other defects of the present Confederation. In addition to the defects already enumerated in the existing federal system, there are others of not less importance, which concur in rendering it altogether unfit for the administration of the affairs of the Union. The want of a power to regulate commerce is by all parties allowed to be of the number. The utility of such a power has been anticipated under the first head of our inquiries, and for this reason, as well as from the indisputable conviction of its necessity, I shall forbear to enter into a detailed discussion of the subject. It is sufficient to remark that the absence of this power has already operated as a bar to the formation of beneficial treaties with foreign powers, and has given occasion to the want of uniformity in the regulations of the different states, which has been productive of the most serious embarrassments to the commerce of the Union. There is another defect in the system which must strike every intelligent mind: the want of a judiciary power. Laws are a dead letter without courts to expound and define their true meaning and operation. The treaties of the United States, to have any force at all, must be considered as part of the law of the land. Their true import, as far as respects individuals, must, like all other laws, be ascertained by judicial determinations. To produce uniformity in these determinations, they ought to be submitted, in the last resort, to one supreme tribunal, and this tribunal ought to be instituted under the same authority which forms the treaties themselves. Without this, the treaties of the United States, under the present Constitution, are liable to be violated by any particular state, and the consequence is that the faith of the whole Union may be infringed by the misconduct of a part. The want of a general power of taxation has already been shown to be a radical defect of the existing system. I shall now add that the want of a power to regulate commerce is nearly allied to it and equally destructive of the prosperity of the Union. But there is still another point of view in which this defect must be considered. It is a source of inequality and injustice among the states themselves. The interfering and unneighborly regulations of some states, contrary to the true spirit of the Union, have, in different instances, given just cause of umbrage and complaint to others, and it is to be feared that examples of this nature, if not restrained by a national control, would be multiplied and extended till they became not less serious sources of animosity and discord than injurious impediments to the intercourse between the different parts of the Confederacy. The regulation of commerce, it is true, has hitherto been submitted to the states, but it has been attended with consequences so pernicious that the public voice now demands a change. Another defect is the want of a sanction to the laws of the Union. The United States, as now composed, have no powers to exact obedience or punish disobedience to their resolutions, either by pecuniary mulcts, by a suspension or divestiture of privileges, or by any other constitutional means. There is, perhaps, nothing more likely to disturb the tranquility of nations than their being exposed to frequent infractions of their laws. This may be said to be the natural offspring of a government which depends upon 13 separate wills. The want of a mutual guarantee of the state governments is another capital imperfection in the federal plan. The United Netherlands furnish a remarkable example of the necessity of this precaution. But perhaps the most palpable defect of all is the principle of legislation for states or governments, in their corporate or collective capacities, and as contradistinguished from the individuals of whom they consist. Though this principle does not run through all the powers delegated to the Union, yet it pervades and governs those on which the efficacy of the rest depends. Except as to the rule of apportionment, the United States have an indefinite discretion to make requisitions for men and money, but they have no authority to raise either by regulations extending to the individual citizens of America. The consequence is that though in theory their resolutions concerning these objects are laws, yet in practice they are mere recommendations. This defect is the parent of all the evils we have experienced. Publius. Brief commentary, biblical and constitutional perspective. 1. Main ideas. Hamilton identifies several critical flaws in the Articles of Confederation. No national control over commerce, no unified judiciary, no enforcement of laws acting on states instead of individuals. At the core, the problem is this: a government without direct authority is not truly a government. 2. Historical context. Written during the ratification debates of 1787 to 1788, this essay helped persuade Americans that the Articles of Confederation were failing. Economic conflict between states, broken treaties, and lack of enforcement were real, visible problems. Federalist No. 22 builds the case for a national court system, federal control of commerce laws that apply directly to citizens, all of which became central features of the U.S. Constitution. 3. Biblical insight. Scripture teaches that law requires structure and enforcement. Where there is no vision, the people perish. Proverbs 29 verse 18. And also, let all things be done decently and in order. 1 Corinthians 14 verse 40. Hamilton's argument reflects this truth. Without order, authority, and consistency, society drifts into confusion and conflict.